before. Mr. Fix pled guilty to specific facts. In a normal circumstance, the law states that you cannot hold his acquitted conduct against him. And I don't think anyone disputes that when it comes to sentencing. However, this particular case is so integrated with actions from so many moving parties. As I was looking at all of the situations, I feel that that particular law should also be applied here. Because while that case looks at specifically one person with their acquitted conduct, it really looks at the conduct. And in this case, although Mr. Fix took a plea, he only pled to 2 specific events. There is a plethora of things that are both in the pre-sentence report and in Mr. Wilson's sentencing memorandum that for the other 3 co-defendants were acquitted at trial. I would ask Your Honor, I think we're kind of making new law here depending on how you rule, but I would ask Your Honor to apply that particular case that I listed in my sentencing memorandum to Mr. Fix and only look at the facts that he pled to when it comes to sentencing him. If we were to look at everything else, including conduct that a jury of everyone's peers felt was acquitted conduct and conduct that was not enough to rise to the level of guilty for the 3 co-defendants, I think if we had included that as consideration in sentencing Mr. Fix, it would be a complete and utter injustice. So I would rely on the arguments in my sentencing memorandum and ask that you not consider that conduct and limit only to what he pled to.
Okay, thank you. Mr. Rahman, any comment from Mr. Higgins on that issue?
None, Your Honor. Thank you.
Mr. Wilson.
I mean, I understand what Ms. Doherty's saying, but he wasn't acquitted. I mean, he pled guilty to the charge, and now we have the guidelines, and we have to decide what to do with the sentence for Mr. Fix. To say that the other defendants' acquittals in some way benefit Mr. Fix factually, I don't think that's correct. The court's allowed to consider testimony that it believes beyond a preponderance of the evidence in terms of Mr. Fix and his conduct in this particular case. It's not that, in this instance, it's really not that unusual. And does the court have any questions?
I do not.
Okay, thank you.
Anything else for you?
Your Honor, I think it is unusual. This hasn't been looked at before, and I think I'm raising an argument that hasn't happened before. I don't think this has been looked at, but I do think that the facts and events that he used as a basis of his plea, that Mr. Wilson and myself and Mr. Fix agreed to as a basis for his plea, should be the only thing that this court considers when fashioning a sentence for Mr. Fix.
Well, it's a very unique issue. Similar to Ms. Doherty, I was not able to find any case law that this issue had ever been dealt with before. I'm not sure if that just means it never made it to the appellate level, or if it is an issue of first impression, which trial court judges never like dealing with. But it's in reference to People v. Beck, which is 504-605. It's a 2019 case. That was a case from Saginaw County where a single defendant went to trial, was convicted of, I think, 2 counts, and then acquitted of 4 or something along those lines. And the sentencing court, as had been done because Beck changed the law, found certain facts by a preponderance, a lower standard than the jury would have been finding by, when making certain sentencing decisions relative to, I assume, the guidelines and things along that nature. And it's a unique request to extend that, where the acquitted conduct of that individual into really 2 layers down, because in the middle of this would be if it were a co-defendant who went to trial and was convicted while the others were acquitted. How do you determine which facts apply to certainly, as part of the trial, both names came up. The surveillance trip up here that Mr. Higgins participated in, some of the actions of Mr. Fix, meetings, and some of the things that he offered came up as part of the trial. But those were tangentially mentioned. They were not necessarily targeted towards these two individuals. And so, based on that, I will deny the request to strike anything on that basis from the PSI, but certainly the issue is preserved for developments. I think OB4 was also discussed by both of you. Mr. Naughton, do you want to start with that one?
Sure.
And I did, just so everyone was aware, I let the attorneys know, if everyone wants to stay at the table to argue, that's fine. If you want to come to the podium, that's fine too. I don't have a preference.
Very good, Your Honor. And I would just be reciting what I've already raised in my sentencing memo. OV4 is one of these OVs that some cases they seem to get scored, some that they aren't. The basis of my objection to this is Mr. Higgins' impact. He was someone that was in a car driving. Afterwards, there was no contact from him. There was no threatening messages, tweets, anything. So I don't say this to minimize it. Obviously, so as Mr. Higgins read the governor's written statement. This isn't to minimize that, but the steps to get to the governor would have had to have been filtered through law enforcement to tell her what Mr. Higgins was doing. And so I think that's too attenuated for an OB4 scoring. Having said that, the scoring guidelines would still be intermediate in both if the court were to grant this objection or not. But I do want to raise the issue. Happy to answer any questions the court may have. Very good.
Ms. Doherty, I assume you have the same objection, perhaps not the same basis, but for all people.
Well, Your Honor, and quite honestly, in reading the sentencing memo from Mr. Rolsting, in my case, he also agreed that for Mr. Fix, OB4 should be scored at 0. I think I also made an argument with regards to PRV 5 for Mr. Fix. However, if for some reason Mr. Rolsting is retracting his agreement as stated in his memo, I do have further argument. But for now, it's an agreement,
It
so
was
I
an
would just
error.
ask that.
The memo was an error. We would ask for 10 points so that she can make her argument.
Okay.
Okay, so they are retracting that
Yeah.
agreement. Your Honor, so I would actually agree with Mr. Naughton, and I would go and further say that there is case law, People v. White, 501 MISH 160 from 2017, that states that just a victim being fearful is not enough to rise to the level of a scoring of OB4. There needs to be more. This court cannot assume, in that the court said in that case, that any kind of serious psychological injury would occur. There needs to be more, such as looking into mental health therapy, documentation through the victim impact statement, anything extra. In this case, in Mr. Fix's pre-sentence memorandum, the victim impact statement, again, like Mr. Naughton said, not to minimize anything to her, but to be quite frank, it didn't even talk about my client. It didn't mention him by name. It just talked in very broad generalities about the case at large. I just don't think that there is enough there, especially considering what this court is required to look at based on People v. White for any kind of a scoring, and that score should be 0.
Mr. Walsh.
Judge, in both pre-sentence reports, there's, well, first of all, there's the governor's victim impact statement, and it really doesn't address directly. You can, if you read between the lines, you might be able to see some, psychological harm to her. The investigator's report, though, flushes out, I think, a little bit more the psychological impact upon her and her family and her husband, her children. She even goes into talk about the neighbors, and I mean, here's really what I'd offer the court is OV4, I think, usually has kind of two assessments to it. One is there's some objective verifiable. I went to the psychologist. I've been having PTSD, and and I've been diagnosed with that. And usually that's not the case. It's just not the way things work in normal life. And then the other, lens that you can look through is, when you think about things in a pragmatic way, just, in looking at the facts that, what would the likely result be of the defendants and co-defendants' conduct, excuse me, on the governor. You know, and when you think about, you know, the driving by the house multiple times, not once, twice, you know, 2 different surveillances, obviously, you know, the governor's aware that, you know, as the world is now, that, you know, there were significant resources put into this from law enforcement in terms of investigatively, and she was being kept apprised of that as, you know, the investigation went forward before the arrest in October. And, yeah, that kind of realization that, you know, you become the governor of our state, and I don't care what party you're in, I really don't. I mean, it's, you know, I'm so far past that. You know, no one deserves to have that threat put before them. You know, there's no conduct that you can attribute to the governor or anybody else that would make that justified. And it's I'll just say it's terrifying. And it's meant to be. I mean, it is intended to be. That's the whole nature of this crime. I'll talk a little bit more about that later. But no, I mean, the idea or the notion that the governor probably today still suffers from that is borne out in the pre-sentence reports. It's not a stretch, is what I'm trying to say. Thank you.
Mr. Nunn,
I suppose just briefly, Mr. Rolston's admitted that the governor didn't state it in her statement, and that this was given through law enforcement because it was being monitored. I'm concerned about the precedent this sets. Just because it's the governor doesn't mean that she is more or less a citizen of our state. People have situations that happen that are terrifying, and there are things our law says that we have to consider and acknowledge when scoring OB4. Those aren't present here. I appreciate what Mr. Rolston said about it being terrifying, but that's not the standard. And so I believe in this case OB4 scoring is not appropriate. But happy to answer questions, of course.
Just briefly, Mr. Rolston is asking you to do exactly what the Michigan Supreme Court is telling you that you can't do. Mr. Rolston is asking you to assume that a serious psychological injury would normally occur based on a particular crime. You can't do that. People v. White specifically said you can't do that. You need more. And in this case, it's not there. We can't just assume because she has a job as a public official that all of a sudden she's going to be more in fear. No, there's not enough there, and a scoring of OB4 of 0 is absolutely appropriate.
Great. Well, we're obviously talking about offense variable 4, which is entitled psychological injury to victim. It is currently scored in both PSIs at 10 points, which is appropriate if serious psychological injury requiring professional treatment occurred to a victim. And then the instructions also note score 10 points if a serious psychological injury may require professional treatment. In making this determination, the fact that treatment has not been sought is not conclusive. The request from both defendants is to change that score to 0, which would be appropriate if no serious psychological injury requiring professional treatment occurred to a victim. And I think that the White case that Ms. Doherty brought up really is sort of the starting point that I always use when it comes to OB4. And I'd also note that OB4, some of the OBs are a little easier to figure out than others, I think, in terms of scoring, right? OB3, what level is the injury? That's pretty easy for everybody. OB4 is a difficult one because it's one of those that involves someone's thinking. And how do we get inside someone's head and make those determinations? And I think the scope of the appellate case law on OB4, which seems to sort of go from one side to the other and, you know, depending on the case, back and forth. So there's really no definitive guide there, but I think White is where we start with because the natural notion for us to say, or would be to say that this act certainly elected officials open themselves up to criticism, to be sure, but this is a case that goes far beyond what that entails, for reasons that we can talk about a little later in the subject matter. But certainly in the victim impact statement that was provided by the governor and in the content of the PSI itself, relative to both her and her family, I would note, she does describe personality changes, the way she approaches things, especially things in public, as well as fright and or feelings of being hurt, unsafe, or violated. So I think that the score of 10 points for OB4 is appropriate, and that will remain, but certainly, again, that issue is preserved for review if necessary. Any further scoring changes? There was the issue for PRV5 as to Mr. Fix. I only saw one prior misdemeanor, so 2 points seems to be the appropriate score, which is what my copy has. Is there any requested change for that?
No.
Okay. Any other requested changes to the scoring? Let's start there. Mr. Balson, let me begin with you.
No.
Mr. Nunn?
Thank you.
Ms. Doherty?
No, no.
Okay. Any other requested changes to the content of the PSI other than what we've already discussed? Mr. Balson?
No, sir.
Mr. Nunn?
I had the two on page 7. Michael Higgins lives in Wisconsin, not Michigan, and Carrie Butler resides in Indiana.
Okay. So we're talking in the grid at the top of page 7, under address, I will change under for Michael Aaron Higgins, I will change Michigan to Wisconsin, absent objection.
That's right.
And was that the same change from Ms. Butler, did you say?
Indiana.
Indiana, I'm sorry. I will also make that change, yes.
Very good, thank you.
Ms. Doherty, any other changes beyond what we've already discussed?
Your Honor, I would like to look at the description of offense narrative that for Mr. Fix starts on page 2.
Okay.
While I understand that you made your ruling with regards to what you're going to consider for sentencing when it comes to this particular PSI, if Mr. Fix is sentenced to any kind of incarceration, this is what's going to follow him. And there are a lot of paragraphs in this offense narrative that, although they have to do with the case at whole, they have absolutely nothing whatsoever to do with Mr. Fix. So there is actually quite a bit that I would ask to be stricken from this offense narrative in order to make this offense narrative much more tailored to Mr. Fix specifically.
Okay. Are there certain paragraphs that you would ask to be stricken?
Yes.
Okay. Which ones?
So looking at page 2,
Yep.
it's the second and third paragraph. The second one starts with Wolverine Watchman. The third paragraph starts with on March 17th.
Okay.
Okay. And then over to page 3, the very top is kind of a continuation, but I'm going to count that as the first paragraph.
Okay.
So then 2, 3, 4, 5, and 7.
So the ones that begin on July 18th and on August 9th?
Correct. So June 20th, on June 28th, on July 11th, on July 18th, and on August 9th is the beginning of those 4 paragraphs that I would ask to be stricken from that page.
I'm sorry, I'm looking at the evaluation plan section, is that where we are?
No.
Description of the offense.
Okay.
Page 3. So you're referencing the June 20th paragraph?
Yeah, the June 28th paragraph.
Okay.
And then the next two underneath that, the July 11th and July 18th paragraph.
Okay, so 4 on that page?
1, 2, and then the very last paragraph where it says August 9th.
Okay.
So I would leave the very top part, and then the August 1st paragraph. I would leave those in.
Okay.
And then the very last paragraph on page 3 goes into page 4, so that continuation. And then where it starts with others not charged and co-defendants charged outcome, all of that information. I don't think there's any reason for any of that to be in here whatsoever with regards to Mr. Fix's guilty plea and future sentencing.
Okay. Mr. Nunn, do you have a position on this? Or?
I don't have a position.
Okay. Mr. Lawson, let me go to you.
I have no position.
Okay. Let me just review the specific paragraphs. describe it. It's the timeline, so to speak, of the events from the case, some of which reference and include Mr. Fix's name, but primarily the ones that have been denoted by Ms. Doherty, they do not. They reference other individuals. The court's going to deny the request, and the reason is this. I think, as I ruled when it came to letting in the evidence, some of which is discussed here, into the trial, for example, I made the determination. I don't know how a fact finder could weigh the materiality for the three defendants that went to trial without understanding what it went to. And as with here, understanding the context of what each of these individuals has pled to, it's important to understand where that fits into the narrative and the timeline. And without having that narrative or timeline in there, and someone can't effectively do that in the court's opinion. And so the other thing I would note too, in the paragraphs, the actions that are described, if they do not involve one of these two defendants, they certainly, those paragraphs list the individuals that were involved in any one of those particular things. So they do note other individuals that were involved. So the court doesn't have concerns that somebody reading this, for example, might look at an event and mistakenly think that one of these two defendants were there, specifically Mr. Fix, because that's where the objection lies, when he wasn't, because it properly denotes, for example, who was at whatever particular event. So for those reasons, I will deny the request. I think in terms of the others not charged and the co-defendants charged / outcome, the court simply views that as information about the case, none of which had any determination or will have any determination in the sentence for either one of these individuals. Honestly, don't even remember whether I looked at that when reading the PSI, to be honest with you. So, but either way, the issue is preserved certainly for appellate review if it becomes necessary. So, any other requested changes to the content of the PSI for anybody? Mr. Ralston?
No, sir.
Thank you.
Ms. Ward?
No, you're not.
Okay. Then with that, time and place for sentencing, what I'll do is allow each defense attorney allocution. We'll go to the people. I'll have some comments, and then we'll get to the sentence for each individuals. I'll just go with Mr. Higgins first. Mr. Nunn, since you all are on that side.
And I'd ask that Mr. Higgins be able to go before me in elocution, if that's okay with the court.
That's perfectly fine.
And today is the time of day set forth for elocution in this matter. Mr. Higgins is present,
Mr.
standing
Higgins,
by.
do you have anything to say for that?
I've read the victim's impact statement repeatedly and in depth, and first I'd like to apologize to the governor and to her family. Generally remorseful of the actions that took place that evening. Second, I'd like to apologize to her security detail that were potentially involved. Third, I'd like to apologize to the citizens of Michigan. I am from out of state, and I'd like to apologize to the court for the time that's been taken and all the resources that have been used as a result of this. I do believe I've changed as a person. I'll be more selective in some friendships that I develop, and that this is not something that I ever intend to repeat.
Thank you, Mr. Nunn.
Yes, we started in 2020. Here we are, almost 4 years later. I talked about this a little bit in my sentencing memo. In the court, and me as a criminal defense attorney, sometimes we see trends. We see things that lead to conduct. We see drugs. We see alcohol. And something that fueled this was politics and how people felt about that. And vitriol, and things that built up. This isn't stated to diminish it. Something I'm personally particularly proud of about Brian is when I first got into this case, we didn't exactly see eye to eye politically on things. But he was at a place where he needed to change. He was at a place where he needed to trust me and the system and how we go about this. Another thing I'm, as an attorney, I struggle to say proud of, but I've read the people's sentencing memo, and there's a lot of stuff about his past and assumptions about the past. But what played out was different. When he was in Luther and came to Wisconsin, he made a mistake, and political ideology transferred into something that was a big problem when he drove north. Now, if he had driven north, come back, and continued the participation, that's a huge problem. That's not what happened. He put his hand on the stove, and he realized awfully quickly that it was hotter than he anticipated. And that was a turning point for Brian, but I don't think the wake-up call really came until he was arrested. So a picture of him with a gun. That wasn't the case when he was arrested. He was detained in Columbia County, and then he met with the FBI. He sought counsel and got it. And then throughout this, as he and I have prepared for this, and there's been some ups and downs, and I'll talk about that, he has steadfastly wanted to do the right thing. We had another meeting with law enforcement, the FBI, and the prosecution. Brian isn't someone who has doubled down. We live in an age of doubling down, especially in cases like this that are embarrassing for people like Brian that haven't been in trouble before. You double down on Twitter. You double down on Facebook. You double down on all of these platforms. That's not what happened here. He accepted responsibility early on, and he continued to act in accordance with accepting that responsibility. There is an issue here with mental health. I can tell you, as an officer of the court, it's difficult to articulate how frightening it is when you have a client who's incarcerated, who is in a real problem in terms of mental health, who is a danger to themselves. And that's something that occurred here. This was not something I knew right away, but I have to give the people credit. When I found out about it, I reached out to counsel at the time who was involved in this. We put the wheels in motion pretty fast to get him into mental health treatment, substantial mental health treatment. That changed. That changed him. As the pre-sentence investigation report shows, he's someone who went through some trauma as a child. There's a lot of stuff that was not resolved or was addressed through anger and frustration. Frustration with his lot in life, frustration with the system, frustration with a whole host of things. I saw a change in Brian when we got him into mental health treatment and he was given proper medication. There was a clarity that came through that changed our relationship as attorney and client. And he was steadfast then. We got to do the right thing. And we continue to have communications with the prosecution in that vein. Brian has done 217 days of jail. When I first met him, it was in the Columbia County Jail. When he was, at the time he had different counsel and there was an issue with fighting extradition. When I got involved, we changed that. We got him to Michigan with no incident. He had a bond, but for reasons that I later found out, because of his deteriorating mental health, he was released and then voluntarily put himself back into the Antrim County jail. He was confused and he was having a complete mental breakdown. It's difficult on this because the victim's different. I have tremendous respect for the governor. I always have. And Brian, I think, has seen through this process. And I think we all need to see it. We're heading into another presidential election cycle. People are getting fired up again. There is a distinction between being frustrated with the system and people in power and doing something about it, taking a step too far. Brian has learned about that. When I talk about the doubling down, this is a case that's generated tremendous publicity, podcasts, blogs, interviews, all of these things, none of which he had any part of, nor did he want to have any part of. He wanted to do the right thing. In this case, probation is appropriate. The law says that that's the case. This is an intermediate sanction case. Even with the court's rulings today on sentencing, his minimum guidelines range is 0 to 11 months. He has served 217 days. Pursuant to MCL 769-34-4A, this court shall impose an intermediate sanction. This isn't to say that he hasn't been punished. He has. And this isn't to say that he should not have probation. He should. One of the things that an intermediate sanction specifically calls for is that. Inpatient or outpatient drug treatment. Mr. Higgins isn't someone who's abused drugs or alcohol. Probation with any probation conditions required or authorized by law. He could use probation. He needs some guidelines as we move forward. Those are appropriate. Residential probation, mental health treatment, mental health or substance abuse counseling, participation in community corrections program, community service, payment of a fine, house arrest. Here's the deal. This has gone on for almost over 3 years at this point. He's been fantastic on bond. We have a proven track record. We have medical documentation to show that things did not go well while he was incarcerated, but he has served substantial length of incarceration. Probation in this case is appropriate. It's appropriate for the community. And one of the things I pointed out in my memo is I don't think the community only responds to punishment. I've been confused by the response to to the verdicts in this case, and people getting citations and things like that from others. That's not the approach that we want to take. We wanted to do our part, have meetings, accept responsibility, and be remorseful. For Brian and the community, that's appropriate for someone that's done the things that Mr. Higgins has done after the arrest. Now, I know the prosecution may say some things, and I've read their report. Our system doesn't allow them to come with me and say, hey, let's see how Brian's doing now. Has he changed? They don't have the point of reference that I had at the beginning when I met him, and the point of reference that I have now of someone who has, we've had some very emotional conversations. He's someone who has accepted his responsibility and is remorseful and knows he has to do better. So I'd ask the court to impose a term of probation, and I think it's appropriate to have conditions for mental health. He doesn't strike me as someone that is going to just say, you know what, I don't need mental health treatment. I can take care of myself. With what he's experienced, he knows he needs mental health treatment. And I think if the court makes it a part of this sentence for probation, that'll be one more guidepost on this to make sure that his trajectory, which has been overwhelmingly positive since his arrest, continues, and he can be a successful and productive member of society. Having said that, happy to answer any questions the court may have.
Thank you. Right. Mr. Don, I'm going to give you the notice of the now.
May I approach?
Yeah.
Your Honor, anyone, judge or attorney that's practiced at all in the field of criminal law knows that a plea happens for a multitude of reasons. It could be a defendant just doesn't want to wait and go to trial, they just want to hurry up and get things done. It could be the plea offer is just too good. Or it could be the fact that they recognize what their actions are and want to take responsibility. In this case, Mr. Fix, from the moment I had my first meeting with him, recognized that he didn't do something correctly, that there was a problem and he wanted to fix it. He had been asking me from the very beginning to meet with the Attorney General's office to be able to help them if there's any way he could help them. Unfortunately, the Attorney General's office took a statement by Adam Fox saying that Mr. Fix is his XO, his second in command, and they ran with it. And it heightened Mr. Fix in their eyes, despite the fact that his actual actions in the timeline that we have do not equate to any kind of a second in command. He admits that he went to a couple of the training sessions where they were practicing their firearms. He admitted to the barbecue at his house that turned into a meeting, and he admitted to giving a general location and helping Adam Fox try to find the governor's summer home. And he's been wanting to fix that ever since. The only reason his guidelines are as high as they are is because national news, international news. Unfortunately, he's stuck with that, and he's gotta deal with that, and his wife has to deal with that, and his children have to deal with that because of mistakes that he made, that he made the choice to own up for him, which is why he took his plea. However, from the moment he got out of jail, he was put on a tether. There were literally zero problems while he was on tether. The only reason we asked to modify his tether conditions is because he's an over-the-road truck driver. He helps get products all over our country. One of the most important people that has came into play when the country shut down, he helped with that. His work wanted to be able to expand him some more. They were running short-handed. All of this happened in 2020, 2021 during COVID. He had never even asked to amend his tether until his work wanted to extend it some more. At the end of the preliminary examination hearing, again, we asked to remove the tether. Actually, I didn't ask that. We asked to amend the tether only to allow him to travel out of state for work. That's it. He had done perfectly on tether. He has not had a single interaction with law enforcement. He has not had a single problem. He has not been online. He hasn't talked to me. He hasn't done anything. He has literally worked and went home and took care of his family. And unfortunately, his guidelines put him in prison. And I think that that kind of a punishment completely disregards what has happened and what his actions are. He doesn't have a history. He didn't come here with a rap sheet as long as my arm. He's not a habitual offender, 2, 3, 4. He has one misdemeanor from 2019, I think, or 2009 or something, forever ago. And he's been exemplary since. This was a mistake. He was not, and I repeat, he was not Adam Fox's second in command. He didn't take that title on himself. He didn't ask for that title. It just happened. It was not something that he had aspired to, and it's definitely not something he tried to do. He did not push and participate in as many things as some others did. I'm asking you to do a downward departure from the guidelines. I asked that in my sentencing memorandum, and I know that, excuse me, I know that with Lockridge, the guidelines do need to be taken into consideration, but they're not compulsory anymore. I also know that you don't have to give on the record these substantial and compelling reasons to do any kind of a departure. However, I think in this case there are substantial and compelling reasons to do a downward departure. As a society, if we only look at punishment, nothing's ever going to get fixed. If all we do is lock people up for crimes they commit, nothing gets fixed. As a country, we need to be looking at rehabilitation more than punishment. And that's what I'm asking for Mr. Fix. He's already been on bond. He was on tether for 2 years. He's been exemplary. He would be an amazing candidate for probation. I understand the guidelines look at prison time. I would ask for 4 or 5 years of probation if Your Honor wants that extended time. And I can guarantee you that he will continue on the exact same path he's been on the last 3 years. So, Your Honor, I would ask that you depart from the guidelines, not take him away from his family anymore, because quite frankly, he's the sole provider for them, in addition to everything else. He goes to prison, they're homeless. They lose everything. Consider the rehabilitative options and give him probation, please. I did speak with him. I don't know if he wants to say anything or not, but I would like to give him a chance to if he does want to have an option, have a statement.
So, Mr. Fix, you have the option, sir, to address the court if you wish. What I always tell people, if you want to say something, it's perfectly fine. But I never want somebody to feel like they have to say something. So what I always tell folks, if you want to say something, that's perfectly fine. It doesn't impact the sentence one way or the other. If you were to not say anything this morning, or this afternoon, excuse me, I'm not going to write, it's not going to be a harsher sentence or things along those lines. So if you want to say something, feel free, sir.
I would. I excuse me, if you allow me, I would definitely stay on the same path that she said, 100%, and solely just take care of my family and provide for them. And that's all I have to say.
Thank you, sir. Mr. Wilson, any comment for you?
Oh, yes, thanks, sir. Just generally starting off, from 30,000 feet. This case is unique in a couple different, well, in a lot of different ways. I mean, you can probably find an infinite number of ways it's unique. But, most of the crimes, not most, 99% of the crimes that we've dealt with as a judge or lawyer, I mean, they're, it's after the event. There's the victim on the ground, there's the bank that's been robbed, there's the house that's been broken into. And, providing material support for terrorism kind of lacks that, injury or that loss or that damage that a lot of crimes do. And we as state prosecutors and state judges and state attorneys, we don't deal very much with terrorism cases. We don't. I mean, Michigan's one of the few states that has, a similar statute to the federal government, and in terms of providing material support for a terroristic act. And I think backing out for a minute, it's worth noting, why do people do terrorism? And how does terrorism differ from everything else I just mentioned? The B&E, the car theft, the assault, those crimes I just mentioned, they usually fall into one, three categories. They're done either because the individual's angry, the individual is greedy, they want money. There's other motives, but it boils down to very self-centered interest in trying to get something for yourself. I mean, terrorism lacks kind of that quality of a motive. I mean, the motive behind terrorism is you're trying to communicate a message to, the population. And the message is be fearful. It's an act of intimidation. I mean, terrorism in and of itself is an act of intimidation. And it's a messaging crime. And I don't agree with you, so I'm going to use either the threat of violence or actual violence to cause fear in you, to cause you to come around to my position. And I can't think of very many things that are more un-American and undemocratic than that. I mean, that's the motive behind a terroristic act, okay? Now, in this particular case, when after the not guilty verdicts, we, out in the hallway, was talking to Special Agent Impola and Special Agent Aris here, and Special Agent Impola pointed something out to me. It's the goal of anti-terrorism investigations is to disrupt the event, is to not let 9/11 happen, not let what happened in Israel in October happen. Stop it. To disrupt the event so that there's no harm. And it was pointed out to me, Bill, that got done here. The governor was not harmed. Her cottage on Birch Lake was not attacked. There was nobody injured from the security detail, and there was nobody injured from any of the local law enforcement. I mean, and that's a good result. It was pointed out to me. You got to remember, the goal here is to disrupt a terroristic event. So, I guess in pointing that out, what I'm trying to say is, I don't think that either Mr. Higgins or Mr. Fix, I'm going to address them individually here in a minute, they shouldn't get benefit because nobody got hurt. Because the reason nobody got hurt, in large part, was because the good work of people from the Federal Bureau of Investigation, people from the Michigan State Police, and there's too many to list, okay? But I mean, one of them sitting here with me today, that's obviously Special Agent Aris. The bravery that Red and the other, undercover agent and Dan exhibited, especially Dan. I mean, special agents, we can kind of reason in our heads, well, they took an oath, and they signed up for this. I mean, that's part of they're, you know, what they do in life, and, you know, thank gosh they do. And thank you. Dan's a unique commodity because Dan's not doing this because he took an oath or, well, he did actually. But he's not doing it because of that oath. He's doing it because I think this is the right thing to do. And so a lot of good people did a lot of good work, which resulted in the disruption of an event that, had it occurred, we'd have been talking about it 100 years from now, or, you know, our families would have been. And, you know, I think it's important to kind of realize that just because no one got hurt doesn't mean, oh, well, you know, it's a stolen car case and probation's the right thing to do and we'll go and call it a day. The next thing I want to point out to the court, obviously, is ideologies are hard to change. I mean, you know, I don't think I need to spend a lot of time on this, but they can be changed over time, and people can have a different way of looking at things. But generally speaking, ideologies are difficult to adjust in people, especially. We're not talking about 15, 20-year-olds here. We're talking about, you know, grown men. And so I think by pointing that out, what I offer the court is, you know, Mr. Fix and Mr. Higgins both bear careful watch. Okay, they both bear careful watch. Talking about them individually for a moment, you know, Mr. Higgins is a unique commodity. And, you know, the DNA or the thread, I think, that runs through his case, it was real obvious. I mean, it was obvious early on, you know, when he had his break from reality. And through a lot of good work of Mr. Naughton, with help from Ms. Donna Monty, who was a member of my department, he got into Munson and really he got probably what he needed a long time ago, okay? And what I suggest is yeah, I think the mental health of a defendant, you know, I mean, gosh, you know, how many times have we as lawyers or judges come across, you know, what's the root cause of this crime? And oftentimes it's mental health or substance abuse. He has that component in his background. That, you know, as I read the PSI for Mr. Higgins, I think the way that I interpreted it was the writer was suggesting to the court, you know, give him credit for time served, 217 days, and close it out. And if I'm mistaken about that, then great. But I do think that he does need some supervision. And the supervision essentially boils down to making sure that he stays within his mental health treatment plan. You know, he has done the 217 days, and it's actually more than anybody else did in the 5 that were here in Antrim County. And you know, punishment is a factor to be considered, one of the 4 factors. I mean, but with Mr. Higgins, I think his conspiracy theories combined with, you know, he's a smart guy. He is. I mean, he's an intelligent individual. I mean, you know, you read the PSR report, you saw his prior work experience, and, you know, it's in a sophisticated area. He bears careful watch, and I mean, obviously, I'm not asking for a guideline, anything outside of the guidelines here. I recommend to the court a guideline sentence for him. With the thrust being that his mental health treatment plan be the focus for him moving forward. So turning to Mr. Fix for a minute, you know, there's a judge in the 30th Circuit who's taught me quite a bit about sentencing, and she had a few things to offer. One of them was, you know, Bill, no one is all good and no one's all bad. And also, we shouldn't really lock up people we're angry with. You know, we may be angry with somebody that we decide needs to go to and have incarceration, but, you know, it's better suited for those that we're fearful of. Okay, I mean, you know, incarceration is obviously the last step in what we might do for punishment in the state of Michigan. But you know, kind of taking those things and applying them to this case, you know, Mr. Fix, he's got some mitigating factors, and I'll talk about those in a second here. But, well, no, I'll talk about them right now. Number one is he admitted responsibility. And, you know, we in the state of Michigan, we don't have a benefit to the defendant in the guidelines for that, and the federal government does. I've always wondered why we don't have that, because it would seem appropriate, people that admit responsibility and take responsibility for what they did. I mean, he obviously got a benefit, you know, he dismissed the felony firearm, so, you know, wasn't, and he's allowed to have self-interest in that point in time. He eventually did cooperate and come in and debrief under a CASTR agreement. You know, those are a couple of mitigating factors for him. You know, and I understand Ms. Doherty's point, and she points out the pragmatic is, you know, he's married, he's got 3 stepchildren, and, you know, if he goes to prison, then they're going to be homeless. Well, I don't know if that's the case or not, but and nobody does, because nobody's got a crystal ball, but I would caution the court to not be swayed by that too deeply. The reality is, and, you know, Mr. Fix is a grown man, he made his own choices. And he knows he's got a family at home that he's responsible for. He chose to do what he did, and, you know, and no, he wasn't at home when he was, you know, in Munich practicing with the Wolverine Watchman and taking an oath of loyalty to Mr. Fox. You know, here's what Mr. Fix did for Mr. Fox. Is, you know, Mr. Fix had the story that he was a former Navy SEAL. And beyond, you know, the stolen valor aspect of it, and applying it more squarely to the facts of this case, you know, that gave Mr. Fox some moxie. It gave him some credibility with guys like the Wolverine Watchman, like Joe Morrison and, you know, Pete Musical and Paul Bellar. And I got a Navy SEAL on my team. And these guys were talking about taking paramilitary action. What could be more sexy or more attractive to this group of guys than somebody saying, yeah, I've been in, you know, the service, I've been a Navy SEAL, I'm an operator, you know, and really let me provide you with my thoughts about how this might be done properly. And that, you know, he wasn't at the bar drinking a beer and talking to some guy in a stool next to him. I mean, you know, he's out at an FTX when he's marketing himself, and FTX being the FTX down in Munich and Jackson, when he and Mr. Fox are with the Wolverine Watchman, and he's being introduced as the XO. I mean, you know, as I think I pointed out somewhere in the month that we were up here in trial, you know, what we do and what we say is attributable to us. And, you know, those things that he helped Fox market himself as a major operator. And I think that Mr. Fix helped Mr. Fox to attract people to him, like-minded individuals that were willing to commit violence, you know. I mean, with that in mind, I would agree he's got some mitigating factors, and he's got some factors that are aggravating too. I don't think it takes him out of the guidelines would be my point. And I'd renew my suggestion to the court that we made through our sentencing memorandum of a guideline sentence. I want to thank the court very much, and staff and the Sheriff's Department for the hospitality that, you know, was extended to us during the course of the trial. It was appreciated. You know, it's always tough when you're in trial, and we're grateful. We are. Does the court have any questions of me, sir? Thank you very much.
Well, the first thing before I forget, the court did issue a limited protective order during the pendency of this case. It protected some of the discovery, it protected some of the evidence. At the conclusion of the sentence today, the case will be done, and so that limited protective order will no longer exist, or will cease to exist, I guess. It's a better way to phrase that, and so the terms of it, once sentencings are completed, no longer apply. And
can I make an inquiry? Sure. And we're crossing this down in Jackson right now.
okay.
Is you know, several terabytes of information, discovery. Appellate counsel wants it, and there's no longer a protective order. and we're not quite into the Court of Appeals far enough to get the protective order right now. You know, it makes providing, you know, if trial counsel doesn't provide the discovery to appellate counsel, then it falls to us. And, you know, I ask for your direction.
As soon as the sentencing is done, this court's jurisdiction ends,
Ends,
and so
right.
the order is done.
Fair enough.
And, you know, it's a difficult case to try to figure out what to say, quite frankly. You can say it's fine. It's such a large case in terms of the volume of whatever There are legitimate ways, of course, to counter things that we disagree with or oppose them. People can run for office. We've seen that recently, especially. People can gather petitions for signature drives. People can take action in court if they think that that's appropriate, etc. And in thinking about whatever list it is of legitimate ways by which we can do those things, they all have one common denominator, and it's that it peacefully advocates for the person's position. There's never violence. Because if violence is ever part of that discussion, then we have lost. In democracy and freedom, political violence is never part of that. It cannot be, by definition. And people are free, of course, to have their opinion. I don't mean to say that they can't. The problem, I think, that then, in moving back to the social media stuff, is that I think today people equate their opinion as being fact, sometimes. And they think that if they believe something that is true, and or they anoint themselves as an expert on a particular topic, and then they think that that equates with an actual expert, perhaps. And as I indicated, and as we talked about in this case throughout and at the trial for the other two gentlemen, having opinions and beliefs is not illegal. There's nothing wrong with that. I don't care if someone thinks that a current or former president, a current or former governor, a current or former judge, even, is good, bad, whatever. People are free to say whatever they want about that person in terms of, I like that person, I don't like that person, whatever policy it is that they did or decision that they made is terrible, and the state or whatever will be ruined because of it. And I could sit up here today even and say anything like that about a current or former president, a current or former governor, whatever it may be, and none of the law enforcement officials are going to come up here and drag me off the bench and throw me in the gulag, because that's not what we do. But we have seen a marked transition in this country towards the acceptance of political violence, and that cannot take root and has to be reversed. This case isn't going to do that. The sentence of this court is not going to do that, no matter what we do here. But from the 100,000-foot view for this case, we are at a very scary place and need to decide where we want to go. But again, this case started because people were upset about some of the actions that Governor Whitmer took through various online sites or introductions at protests, whatever it may be. Sort of a network is formed, and various levels of authority for various folks throughout those networks, at least in the information that's been presented as part of this case as a whole, and certainly at the trial. Adam Fox and Barry Croft are sort of at the top of that pyramid here. And people are free to think of whatever they want about the case. Not even the court has seen the terrorist discovery that the attorneys have talked about. I'm familiar with the documentation from the filings in this case when we've had motion hearings. Obviously familiar with the facts as they were presented at trial. And the trial was a month long. I'm not going to run through all of the facts that were presented, but there are verifiable things that happened. There was a meeting in Dublin, Ohio. It was attended by dozens of people. At that meeting, attacking various levels of government was discussed in detail. There's audio recordings of that meeting, so we know who was there, we know who said what. And again, I don't care what anyone thinks about a particular person in government. I don't care about who they voted for, the political party. The fact that that meeting occurred and anything like it should be concerning to everybody. It is not normal, and it cannot become normal. A common response that I've seen as part of this case, and even here for some folks, is that they thought that these people were joking, that they weren't serious, they were trying to blow off some steam. And certainly, we all have said those things as people, right? We're very upset, we say something in the moment, to be sure. But again, when you look at the recordings of the Dublin, Ohio meeting, let's just use that since I referenced it, nobody sounded like they were joking. When explosives were being created and didn't neither of you have to be defined by this case. Certainly, anyone who has been charged and is a part of it will be associated with it, but it doesn't have to define you. The court's goal simply is to hold you accountable for your actions. So with that, Mr. Higgins, I'll start with you. In terms of the sentence for both of you, there are 4 factors, of course, that have been referenced by all of the attorneys: reformation of the defendant, punishment, deterrence, and public safety. You have served 217 days, and Mr. Naughton correctly cited 769.34, which, given that your guidelines, which I do find to be proportionate based on the information contained in the PSI and the information from the case, to be proportionate. I'd also note that there were some matters to be dismissed. They're dismissed at this time, and as I've indicated, you do have 217 days credit. That will be applied to whatever sentence I give. The court has to start with the default position, and the law says that the default position is an intermediate sanction, as was referenced by Mr. Naughton. And the default is no jail. It is an intermediate sanction which would focus on rehabilitation, probation, those types of things. And the statute does provide, if there are reasonable grounds, then the court can sentence an individual with those guidelines to jail. And I think that what the court has to consider in a case like this, quite frankly, I think public safety, number one, and deterrence are very primary factors that the court has to take into consideration. Very important factors, excuse me. Punishment is also important, but reformation of the defendant also has to be part of that. Because the goal with any sentencing, quite frankly, there are very, very few cases where somebody's locked up and the key is thrown away. So people are coming back into society, regardless of length of time for which they'll be away. And I think it's important to note, too, that the court, in terms of the reasonable grounds for adding any jail time, if I were going to, the court cannot take into consideration things that are already part of the case, that were already part of the pre-sentence investigation. And I think even though it's important to send a strong message to you, there is, I guess, on some level, the deterrence factor and punishment as a whole, but I focus on the individual in front of me. Society is going to do whatever it's going to do, regardless of what my sentence is in any particular case. And so the court does think probation is appropriate in your case, not a straight jail sentence. So I will sentence you to 36 months of probation, the terms of which will be created by the department and then reviewed by me. I would ask the department to focus on mental health as part of that, and very specifically trauma. I think that certainly there are some mental health concerns, but I think the original trauma is exacerbating it, if not fully causing it, and that needs to be examined. The other thing, because 769.34 was changed a little while ago to its current form, and when they changed that, they also changed some other statutes, one of which provides that halfway through a probation term, the applicant, being you in this case, if they have done everything that they need to, if all of their fines are paid off, you do have the option to petition to get off probation early. What I always tell people is that's up to you. Certainly I will review everyone, obviously, every request that I get, but that depends on you. Right? That depends on how you're doing, and if you have made those changes, certainly the court will look at it. Obviously, given the nature of the case itself, that's also considered by the court. I'll just be frank with you about that. But certainly we can take a look at it at that time. And the other thing, sir, is obviously in reviewing the PSI, and Mr. Naughton touched on it a little bit, for incarceration in the future, I'm going to sentence you to 217 days in jail. You do have credit for 217. That's far in excess of the default of 0. What I will tell you is, as part of that decision, are the significant mental health things that are outlined in the PSI. What I will tell you is that if there are any issues on probation, the benefit that you received today of those being in your background will not be the case in the future. Okay?
Understood.
In addition, there will be fines and costs that are associated with your case. There will be a fine of $100, court costs of $350, state mandatory cost of $68, crime victims fund of $130. There is no attorney be given that Mr. Naughton is retained. And Agent Myers, just for the terms of probation, 8.3 then, or excuse me, 3.8 would be applicable, given that it's a retained case. Is there any restitution sought, Mr. Ralston?
I'm sorry?
Any restitution
No.
sought? Restitution will be set at 0. Mr. Naughton, first, any questions for you about the sentence? Secondly, I gave you the copy of the appellate rights form. Mr. Higgins, you do have the right to appeal both your conviction and sentence, sir. You have the right to the assistance of an attorney in helping you accomplish that. If you think that you qualify as indigent and would like to request a court-ordered attorney to help you with that, you would need to complete that paperwork and return it to the court office within 6 months, okay? There's a section on the paperwork that you're going to sign and date today. That's simply acknowledging it. That's simply acknowledging that you received the paperwork, okay? You'll get several copies and several will go back to the clerk. If you actually want to pursue the appeal and seek getting an attorney, you need to complete the paperwork that you're given today, and then that's what you would return to the office. Do you understand? Okay. And if you wouldn't mind having a second as well, sentence Mr. Fix, and then everybody can get together. Okay. Moving on to Mr. Fix. Sir, the guidelines in your case are 24 to 40 as they were calculated. And Ms. Doherty is correct that Lockridge, well, I was going to say clarified the issue as to guidelines. I think it made it muddier, quite frankly. And I think the Supreme Court found that out when they tried to have subsequent appellate cases after that. But regardless, courts are in the position where under certain circumstances, the guidelines can be ignored, so to speak. They're not compulsory, they're simply advisory. And the court has to take into consideration that that is the status of the law. The court isn't the one who assigns the sentencing judge, the legislature is the one who does that. And the parties are the ones who determine what the plea will be, and you accepted that plea. And so I do find those guidelines to be proportionate as scored. There were some matters that were to be dismissed in your case. I would note that they're dismissed at this time. You do have 34 days of jail credit, which will be applied against any sentence that I issue. And obviously the same 4 factors apply to your sentencing, sir. And your involvement was more than Mr. Higgins, and that may be why people made the decision that they did in terms of the plea agreement offer. But that part's not up to me. The information that I get or the decision that I make is based on the information that I get. And the one thing that I would counter specifically that Ms. Doherty said is I'm not the one taking it away from you. Your actions. The sentence of the court is going to fall in line with what the law says is appropriate. But certainly that's not something that the court does. And just as I'm not sentencing somebody for anger or fright, sympathy for an individual also can't come into play. Whether that's for a defendant, whether it's for a victim or anybody else, because then it becomes subjective instead of objective. And we can't have that because we need people making decisions based on the objective information. And from the case, it's very clear that you wanted to be involved in this when they were discussing the plan. You provided numbers that you thought were appropriate in further discussions. There were details of things that you had offered, such as a helo and a Connex box full of weapons. There was a meeting that took place at your home. And the notion that I was left with was that if you wanted to get out, you could have. And you and some other individuals indicated that you were scared. But I don't know how to balance that with we thought they were joking. Because if they're joking, then why are you scared? And certainly, I guess I could understand the fear of reprisal if you were going to go to law enforcement or something, maybe. But just simply ignoring them and going away and fading into similar to what you just heard me say about the notice of appellate rights. Obviously, you have one too, and you have the right to appeal both your conviction and sentence. You have the right to the assistance of an attorney in helping you accomplish that. You have the right to the assistance of a court-appointed attorney in helping you accomplish that. If you think that you qualify as indigent and would like to request a court-appointed attorney in helping you pursue an appeal, you'll need to fill out that paperwork and return it to the court office within 6 months, and your request will be considered. Just as I told Mr. Higgins, you'll sign a portion of it today. That's simply indicating that you receive the paperwork, sir. If you do want to pursue the appeal, you would need to complete the rest of the page, fill it out, and return it to the court office within that time frame, and then it will be considered. Do you understand?
Yes.
Okay, thank you.
Your Honor?
Yes.
Just for the record, you mentioned jail credit fees.
Oh, for Mr. Higgins, it was 217. For Mr. Fix, it was 34 days.
Thank you, Your Honor.
And I should have asked, anything else that I left out that you all need?
No, Your Honor.
Okay, or from the clerk's perspective? Okay, thank you all for adjourned.
Thank you.
And as I indicated, given that the case has concluded, the limited protective order is now no longer in effect.
Mayor, may I tender some